Good afternoon. I'm Professor Charles Rose, Director for the Center for Excellence in Advocacy at Stetson University College of Law. And I want to talk with you today about opening statements. It's that moment when we pause a while and let the counsel sway you in the case. Openings are important for resources. I'm relying upon my fundamental trial advocacy text, my fundamental pretrial text, and the online advocacy resource center here at Stetson University College of Law. The ARC here at Stetson is part of our attempt to assist public service attorneys and law students in developing those skills so that they can be effective advocates and persuasive ones. During opening statements, it's our opportunity to introduce our case to the jury. It's that moment in time when we first begin to tell the story in a cogent and cohesive way that's coherent for the jury. This is an important time in the trial process because the jury is focused at this point on what it is that's being said by both counsel because they're trying to choose the version of events that they think is most likely. Jurors develop their factual focus during the opening statement. The opening statement provides them context so that they can understand the testimony of witnesses and the evidence that is presented. In fact, there are a lot of studies that seem to indicate that jurors, like most human beings, when they hear a story and elements of the story are missing, will begin to fill in those pieces of the story that are not available to them based upon their own personal experiences. So opening is that opportunity for you as the attorney to set the stage to bring the jury to your factual focus so that they will accept the ideas that you're placing forward, which can be crucial as they go through the determination of the credibility of witnesses and what facts have or have not been proven later on in the process. How do you prepare for opening statements? Well, I would suggest to you that at the very beginning, case analysis is your benchmark. You look for your legal theory, you look for your factual theory, your moral theme, your persuasive story of the case. You know that's what you're going to say in closing argument. You know what the testimony of the witnesses will be, and opening is your opportunity to set the scene. And the filter for what you talk about or what you don't talk about during the opening statement is relevancy. Relevancy is the key as to whether or not this is part of the story that should be told. And relevancy is driven not only by the rules of evidence, but by your case analysis, by the story that you are telling. And that's an important point here, because we truly are storytellers during the opening statement portion of the trial. As you look at relevancy, there's a three-question test that you should consider when deciding what story you're going to tell the jury. Are the facts that you're talking about facts that will be remembered by the jury later on in the trial? Are they facts that will assist in setting the scene for what occurred during that time frame? And are they going to help the jury in understanding the legal issues or the factual issues that are before them? If any of these three are true, then this is a part of the story that you should consider telling during your opening statement. Now, how do we structure this story that we tell? Well, usually there's a hook. There's a pithy saying, a thematic portion of the opening statement that sort of sets the scene for the story that you're about to tell. And if you go back and look at the advocacy training modules on case analysis, you'll see that we talk a great deal about theme, sense of injustice, the most appalling thing. That hook is what you hope spins the opening statement in a way that the jury is receptive to it and they find it believable. And then you tell the story, which is facts, facts, and more facts. And you want to tell that story in a first-person sense so that it seems to the jury as though they're there. And then you'll foreshadow the law so that they'll know what law it is that they're going to need to rely upon later in the trial. But the vast majority of the opening statement is spent telling the story of what happens. And then finally, we tell them what we're going to want at the close of the case and what we think the law will demand. Now, you want to use case analysis to help prepare your opening statement, and I would suggest to you, much as I discussed in the advocacy training module on case analysis, that you use the rule of threes. Think about your entire case from the standpoint of opening statement, case in chief, and closing argument. You know what your moral theme, your factual theory, and your legal theory are. Your moral theme, as we mentioned earlier, is the hook. The factual theory is the evidence, and the legal theory is the law. We know the witnesses are going to talk about this during testimony, during the case in chief. And in opening statement, we tell them the why, the what, and the how. The factual theory is what happened. The legal theory is how it matters. And the moral theme is why they should decide the case in your favor. Now, there are 7 steps that have been identified that, by and large, if you can follow them, will put you well on the path towards having an effective opening statement. First of all, you want to start with your theme and end with your theme. You use primacy and recency. Jurors usually remember the first part of any presentation and the last part of any presentation. So you use that concept of primacy and recency to start strong and end strong. We want to structure this opening to include facts, law, and morality. We want to use descriptive language. And by use descriptive language, I mean get rid of passive voice. There's no has been, was, were, could, would, should. All first person. On the 21st of June, Jeremy gets up in the middle of the night, and he staggers down the hall and opens the door, falling to his death. Now think about that little bit right there. Every bit of that had a first person present tense verb. The beauty of that sort of language is it immediately pulls the juror in, it pulls the human being in, and because you talk about it in the present tense, it seems like it's happening as you speak. And then you want to communicate directly with the juror. You want to use eye contact and body language to establish rapport. And you do this continuously throughout the trial. You begin it in jury selection, but it really comes into its own during opening statement. We'll talk about that a little bit more in a moment. You want to set the tone and pace for the trial. You want to outline your case with confidence, but you don't want to make promises that you may not be able to keep, because if you do, opposing counsel is surely going to make certain that the other side knows about it and talks about it during closing argument. You want to tell the jury what you want and what the evidence demands. Quite often, in an opening statement, we get so wrapped up in the telling of the story that we don't quite know how to end. One effective way to do it is like this. Members of the jury, at the close of this case, I'll come back to you. We'll talk about the evidence. We'll talk about what's been proven and what hasn't been proven. And together, we'll come to one conclusion. The state's case has simply not been made. And I'll show you how the evidence will demand that my client be found not guilty. That's a classic example of telling the jury what you want and what the evidence is going to demand. And then you want to tell the story of what happened and why it matters. But again, do not overpromise. Well, those are 7 steps that identify some fundamental concepts of opening statements, but they don't really give us a lot of meat to put on the bones for the actual skills performance. I've got a schematic up here of a courtroom, and there are a couple of things that I want you to do as you look at this diagram. See the circle that's in front of the jury? Now, at the very beginning of the opening statement, you have the jury's attention. They're at their peak moment of focus on you. So you get up from counsel's table, the justice counsel, you may begin with opening statement. Thank you, Your Honor. You're absolutely silent. You walk out and assume this position of persuasion. You stand there with your feet comfortably shoulder width apart, maybe a little bit more. You let your hands drop to your sides. You look at the members of the jury, and you wait until they give you permission to speak by making eye contact with you. And then once you do that, you move with a purpose so that every time you're making a point, your hands automatically move to persuade and not out of any nervous tension. If you'll begin your opening statements in this fashion or some fashion similar, if you'll work on your physicality, your presence in the courtroom, what you'll find very quickly is that that gets out of the way, and it automatically happens and becomes an expression of you. an expression of your thoughts, an expression of your passion, an expression of the emotion that's within the case, which is exactly where you want to be. Now, language has power. Language has particular power for attorneys, and we spend a great deal of time in law school and in our professions developing the use of words. The problem is that some of the words that we develop as lawyers don't translate well into the normal vernacular, into the normal pattern of speech. And so when talking to juries, you want to do a couple of things. You want to use short, concise words. You want to use words that create pictures in the mind of the jury. You want to get rid of unnecessary words and doublespeak. Let the cliches and the clutter go unless they're effective. And then you want to use forms of language that enhance retention. Forms of language that help the jury remember. What would be some examples? Well, take a look at these. On the left-hand side of the slide are classic examples of short, concise words spoken in plain English. And on the right-hand side of the slide are those double-take, cop-speak, lawyer-speak words that often occur instead. You want to get rid of vehicle and you want to say car. After is much better than subsequent. See is better than observe. Buy or get is better than to acquire. You want to sound like everybody else. You want to sound like a person and not like a lawyer. And using short, concise words can help you with that. Here are some more that you want to think about. Go, ask, find, place, help. The more concise the word, the more normal the word, the more persuasive its use is. Now, words can assist you in drawing pictures and in making something appear. And I want to show you a classic example of that. Read this following quote on our PowerPoint slide, and I'll read it to you as well. Objective consideration of contemporary phenomenon compels the conclusion that success or failure in competitive activity exhibits no tendency to be commensurate with innate capacity, but that a considerable element of the unpredictable must invariably be taken into account. Could have been written by almost any law professor or English professor on any university campus in the United States. Now let's look at the original. I returned and saw under the sun that the race is not to the swift, nor the battle to the strong, nor yet bread to the wise, nor yet riches to men of understanding, nor yet favor to men of skill, but that time and chance happens to them all. These two passages say exactly the same thing, but they say them in a very different fashion. One is officious, it's academic, it's erudite, it shows a great deal of, as my family would say, book learning. The other one speaks to the spirit at a much more basic level. And when persuading jurors, you want to speak to the jury at that basic and fundamental level. You want to get rid of those unnecessary words that lawyers sometimes use. I want to show you some classic examples. Uncontrolled contact with the ground, otherwise known as an airplane crash. Diagnostic misadventure, malpractice. Terminal living, dying. Negative patient care outcome, the patient died. Extra pair copulation, otherwise known as adultery. Non-decision making status, one of my personal favorites, unconscious. Grain consuming animal units, livestock. All of this language has been taken out of actual cases where attorneys, in an attempt to be persuasive or to deflect attention from the case, use these unnecessary words of doublespeak. You don't want to do that. You lose credibility and you don't sound normal. Get rid of them. They're not effective for you and they're not helpful. Now, you also want to use language forms that enhance retention on the part of the jury. What do I mean by that? Well, one is repetition. If the jury hears something 3 times, it greatly increases the probability that they're going to remember it. And we talk about the use of repetition in our asking questions ATM modules. We talk about it in direct examination and cross-examination. We also discuss it in case analysis. It works here in opening statements as well. Another thought is parallelism, when you can combine 2 ideas together and juxtapose them to one another so that the jury draws the conclusions from them. In our module on case analysis, we give you some excellent quotes from Elizabeth Cady Stanton, from President George Bush, from Dr. Martin Luther King Jr., all of them using parallel thought, along with the rule of 3s to be persuasive. And then finally, the rule of 3s. When you communicate ideas in groups of 3s, it creates a sense of completeness and significance. Jurors are more inclined to believe them. So, we've reviewed the law. We've talked about some fundamental principles of how to do opening statements. We've talked about physicality, and we've discussed some of the things that you should think of. Now, there are some things that you should not do, and I thought I would give you 12 steps to a bad opening statement. You don't argue. This is a time to tell the story of the facts, not to argue the impact of the law on the facts. The most common mistake made by attorneys is to argue in opening and to open in closing. Why? Because you've lived with this case for the entire period of time that you've been investigating it. You're so prepared to explain why your side should win. And so you stand up in opening statement and begin to argue law when the jury has no context to understand the law. The opening statement is the time for the facts, and that's what you should do. You don't want to use a table of characters. Witness X, witness A, witness B, witness C will all come in here and they'll tell you E, F, G, and H. A table of characters doesn't give context to the jury. It just gives them a list. You don't want to give a course in trial procedure. You often see someone come in and begin an opening statement, members of the jury. I'd like to thank you for your time today. We're here because this is a trial and I'm about to give you an opening statement. After I give an opening statement, the opposing counsel will give an opening statement and then the judge will talk to you. Then we'll begin to call witnesses. Please understand that an opening statement is just my version of the facts. It's not evidence. You really don't have to pay attention to it, and there's no requirement that you listen to what I'm saying or that you believe it, but this is my opportunity to tell you what I think happens. A classic example of giving a course in trial procedure, it's not useful, it's not helpful, and you're losing that opportunity to set the scene for your case. By the same token, you don't want to give disclaimers of credibility about why they should not pay attention to you. I would also recommend to you that you don't want to use the phrase, the evidence will show. Now, why have attorneys been taught to say, the evidence in this case will show? Because evidence professors have taught them that if you say the evidence will show, you can avoid an objection as to facts not in evidence at this time. You don't need these magic words. You merely need to make a statement of a good faith basis of what you believed happened. The evidence will show has been overused, and it's really not necessary, and it gets in the way of persuasive advocacy. You don't want to talk about evidentiary uncertainty in the case. This is your time to focus them on what you know, on what your story is, not on the problems with your story. If you want to preface weaknesses in your case, you don't do it in the beginning of your opening statement. You don't want to engage in prohibited conduct. If you know that there's evidence that is going to be excluded, there are arguments that you cannot make, it's exactly the wrong thing to do to cross that line and then do that during opening statement. You don't want to make any admissions about the case that will bind your client. You don't want to make promises that are not so or that you're not required to take on. You don't want to appeal to passion or prejudice when it is not warranted by the facts in that particular case. You also don't want to write checks with your mouth that your bank account cannot cash. Don't overstate your situation. You want to give it to them clearly, you want to give it to them properly, but don't make promises that you cannot keep. I also would suggest to you that opening statement is not the time to play off the other side. Well, what do I mean by that? Sometimes you'll see a lawyer get up and go, now members of the jury, my opposing counsel is going to get up and he's going to talk to you about X, Y, or Z. First of all, you don't know that that's what the opposing counsel is going to do. Secondly, you're taking your time to focus the jury on the other side. That's not the most effective use of your time for your story, and I would suggest to you that there are better ways to crack that particular egg. And then finally, you don't want to talk about the law, you want to talk about the facts. You just preview the law in the very end of the opening statement. Now, just as there are 12 steps to a bad opening statement, there are also 12 steps to a good opening statement, and you can do the following to come in from the cold and to find yourself with a powerful, effective opening. Give a theme. Tell your story. Create that sense of injustice that will get the jury to decide the case in your fashion. Personalize your client. Keep it simple. Give only the necessary details. Start and end strong. Use action words. Tell the jury what you want. Be cognizant of the burden of boredom. Don't bore these people. Make yourself credible and use exhibits. Exhibits are one of those tools that you can use in opening statement, witness testimony, and closing argument. Extremely powerful, and we quite often don't do them. Now, before we conclude, let me give you an example. Your Honor, may I proceed with opening statement? "1323 Mockingbird Lane is a row house at the end of a set of townhomes, and it's got a red brick bottom and an aluminum siding top. It's a two-story building. And it's the corner lot, and as you walk down Mockingbird Lane and you get to the end and you turn and look at that home, there's a chain link fence that runs all the way around it. The fence is a little rusty. The top's bent from where kids have been leaping over the top. The poles don't lay as straight as they used to. And if you open up the gate and you go into the yard, there are little tyke toys strewn about everywhere. There's a little Tyke's playhouse with the red roof, the yellow shutters, and the little green door, a little red door, and you go inside, there's a little desk where kids can sit and play and have tea. And lying on its side is a blue elephant. The little blue elephant's little Tyke slide. And the right eye of that elephant is looking at the door. You go up to the door, it's a screen door, and you can go inside. And this is where Sarah lives. Now, Sarah's 5 years old, and she's going to come talk to you today. When Sarah plays in her front yard, it's a happy time. She loves her brother. She loves her toys. And sometimes, when her daddy calls her in the house, it's a good time. And Daddy calls her in the house, and he takes Sarah by the hand, and Sarah can look up the stairs. And Daddy pulls her up the stairs. Sometimes it's a happy time, and sometimes it's not. Sometimes Sarah's shins beat against the wooden risers as she goes up the stairs. And when you get to the top of the stairs and you look straight ahead, that's Grandma's bedroom. Grandma lives with Sarah and her brother Brian and her mom and dad. And Grandma's bedroom is a happy place. She plays there, she reads stories. And if you turn to the left, over on the left-hand side is Sarah and Brian's room. And they've got bunk beds and toys, and it's a happy place. Then when you turn to the right again, that's Mommy and Daddy's room. And sometimes that's a happy place, and sometimes it's not. Sarah knows if her time in Mom and Dad's room is going to be a happy time or a sad time. When Daddy goes inside and reaches up onto the top level of the shelf and grabs the love juice. Members of the jury, we're going to bring a bottle of that love juice into this courtroom today. We're going to open it up, and you're going to smell the strawberry smell that Sarah will sit in this witness chair and tell you she smelled every time her father sexually assaulted her. And at the close of this trial, I'll come back to you, and we'll talk about how Sarah's testimony, the love juice, will lead you to one unalterable conclusion. You must find her father guilty of the offenses which the state has charged him. Thank you. Now, that is an example of an opening statement, somewhat truncated, but built and using all of the effective techniques that I've talked with you about during this advocacy training module. Good luck. I look forward to seeing you somewhere down the line. Thanks.